Bennett,
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just for 25, PCS, unauthorized use, and now you have an evading arrest.
Those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat.
good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to is this on doctor?
It's on docket.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
I do understand that.
This isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No. Once you plead guilty, It stays with you forever. You never change it.
Direct those of the trouble.
If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can talk to you about that case, right? You're telling me that it's self-defense, then
A child a day?
Yeah. We don't do that.
She's gonna show up.
She will.
Guys, I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We will for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
Morning, Mr. Tolentino.
Good morning.
So you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully if you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change. No drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're on probation as well. I'll make you a deal. If you do well, you get everything done quick. I'll take you off in half the time, meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
Sir.
All right, bud. Good luck to you, sir.
Thank you, Judge.
Thanks, John. Mr. Aguilar, you're charged with failure to stop and give information striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take it, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
And he was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right?
Yes,
It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Better to stop and give
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
You
no,
have
sir.
the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So
Yes, sir.
just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Chimeo.
Good morning.
Good morning.
Charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. You ever get pulled over again, officers will see this DWI and they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Sí.
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, meaning once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do?
That's it.
Yes.
Is it true or untrue that you had a .15 or above breath test?
¿Verdad?
True.
Find that it's true. I'm now going to sentence you to the 27 days, give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you, sir. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe sentence status has changed since then. Can we have the court waive the DPS fee? Thank you, Judge.
Hello, Judge. Can you hear me? Yes, yes. I believe Ms. Parks appeared, is my understanding.
Give me a second. Hold on. Let me just stop this back. Okay, what?
Yes, yes. So it's my understanding Ms. Parks earlier, but she's there now, Judge. And so Victoria asked me to
Page 36, Park, she's set for trial and showed up at 1 o'clock.
Today is your trial setting, and you show up at 1 o'clock. Really?
I didn't start later, but I got lost.
I'm sending you for a drug and alcohol test right now, and then I'm rolling your case until tomorrow. You must be back here tomorrow.
This isn't just a
One,
sentencing speech.
two,
This is a
three,
warning wrapped in
four,
frustration.
5,
The judge
six,
isn't punishing
seven,
just to punish.
8,
He's trying
9,
to interrupt
10,
a cycle before
11,
someone gets
12,
killed.
13,
One button,
14,
one ride,
15,
one
16,
decision.
17,
And yet we
18,
keep seeing
19,
the same
20.
defendants come back.
Now,
Be
20.
honest. Do
One
harsh consequences actually change behavior? Or
just
is this
since
system
2020.
stepping in too late?
How a line every time you How you doing, sir?
You're charged with failure to comply with, basically FSGI, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Thank you, Your Honor. On March 22nd, 2025, in Harris County, Texas, the complaining witness went to the police station to make a report for someone that struck her vehicle and failed to stop and give information. On March 24th, 2025, the officer reviewed body-worn camera where the complaining witness stated that while she was at a soccer game, someone struck her parked vehicle. The complaining witness stated that another witness left a note, and that witness observed the defendant strike the complaining witness's vehicle and leave without stopping and giving information. The witness stated the defendant was the coach of the opposing soccer team. The complaining witness stated that they talked to the defendant, but the defendant has failed to provide their insurance information. The officer met with the witness who viewed the accident and administered a photo array. The officer observed vehicle damage from the defendant and the complaining witness consistent with complaining witness and witnesses' accounts of events. The officer observed text of the complaining witness communicating with the defendant. In those texts, the officer observed the defendant state he is responsible for the crash and he has no problem paying for the expenses out of pocket. The complaining witness obtained a written estimate of cost of repair to her vehicle of $1,975.78.
Okay. Mr. Mohammed, I'm going to find that there's sufficient probable cause to go forward with the case. Does he have a license? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
He does, Judge.
I'm also ordering you not to go back to the soccer field. Do you understand? If I find that you pick up a new case, if you go back, I will revoke your bond, put you in jail. No more.
Judge, may I? Is there any way we just do no contact with this person? Because in this club soccer world, there's only like 2 to 3 fields that they play on. My daughter's played Albion and there's only like 3 parks that they play out. So can we just,
It's to happen again. And
I understand. Can we do a no contact so that he's not around that person? Because he's the head coach of the soccer team. And we're going to get this taken care of pretty quick. I think they agreed that if he pays restitution, they're fine with it.
how is it going to be possible if they're still playing soccer that it's going to?
I think he can avoid them. These parks are big. There's Dice, Zuby Park.
Yeah, sorry.
Go ahead.
First of all, sir, I've never had contact with the woman who claimed these claims. That's one. Second of all, I never left the scene because I had to.
I'm not going to argue with.
No, of course, I understand.
We're not arguing the case.
Sir, sorry. Yes, I'm just trying to clarify that there's no contact between me and the or whoever's making the complaint at this moment. I've never had contact with her in my life, so there's no reason for any non-contact going forward, as I said.
Before he's allowed to drive, I want proof that he's got liability insurance, and I don't want you to have contact with the complaining witness. If I find that you get into another accident, if you're a danger to my city, I'm gonna lock you up. Do you understand, Mr. Muhammad? Okay.
Thank you, Judge.
All right, we need to put bond conditions. We need to show proof to pretrial that he's got insurance, and then we'll allow him to drive.
Thank you,
Yes, sir.
Good morning, Mr. Hissa. So you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On March 26, 2025, in Harris County, Texas, an officer was dispatched to a vehicle accident. The complaining witness stated he was driving when he noticed the defendant was tailgating him in his truck. The complaining witness stated he brake checked the truck. The complaining witness stated he attempted to change lanes to let the defendant through. The complaining witness stated the truck went around him, got on the median, and then collided with the complaining witness's vehicle on the side. The complaining witness stated the defendant pulled ahead of him and turned to leave the scene. The complaining witness stated he followed the defendant and got in front of his truck to prevent him from leaving. The complaining witness and the defendant exited their vehicles. The complaining witness stated the defendant came up to his face and was yelling that the defendant was trying to find a good place to stop. The complaining witness stated the defendant got in his motor vehicle and left without providing his driver's license or insurance. The complaining witness stated he did not want to press charges. The complaining witness estimated damages to be $500. An officer ran the plate provided by the complaining witness. There was a driver's license attached to the plate. The officers ran the attached driver's license and got a return photo, and the complaining witness ID'd the defendant by this driver's license photo that the officer showed him.
Mr. Hissa, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running his license, please?
Yes,
The
Your
city
Honor.
has a valid license. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If I find that you drive without either, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer?
I think so. Yes,
Okay,
yes.
we'll give you time. If you have any problems, just come back and talk, and then we can go further. If you need an appointed lawyer or anything, we can always have you fill out an application. So for now, I will have you go to Victoria, sign a reset. We will then have you take a seat in the jury box while I get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go. All right? Please.
Judge, for what it's worth, my client, assuming the court's okay with it, would like to apply for an driver's license after this. We'll be working on getting those documents together if the court's inclined.
I don't know about doing a time served. He just had one dismissed and he's back now, right again with another DWI, and it's a point, and it's above a 15. I mean, really?
Sure.
We're still going to continue to do the same thing over and over and over? No, I know you're saying no, but here you are yet again. You had one dismissed, a year and a half ago. Now you're back on another one. It's above a 0.15.
If you gave him, if you got an occupation, the court could order some level of treatment, Judge.
He has to do treatment as part of it. So what we do is we'd have him T-RASed, but if I accept this, I'm sticking him with the fine. I'm not going to let him go without the fine.
Would you impose a fine on the probations?
No.
Let me talk.
Talk to him. It's 4,500 as well, too. No, I'm sorry, 6,000. I need you to understand that in life, right, we're not going to continue to hope and pray that something bad doesn't happen. We sometimes have to take proactive measures to ensure. You just had one dismissed. You've now picked up another one. If I were to plead you to time served, another proverbial slap on the wrist, and now we're going to let you go out there and hope that you don't kill someone or maim someone or you don't pick up another one, No, that's like the definition of insanity, wishing that something, over and over, just with a different result. No, this is proactive because here we can see what the issue is. We don't want you to come back with another DWI or much more kill someone because, look at the news. Every day someone dies from a DWI, and it's just not fair when it's so freaking preventable by one damn button on your phone. How much money have you spent on both DWIs so far where one button and a $40 fee would have gotten you from A to B? You know what I mean?
Sir.
That's now what we have to do to intervene in hopes that you learn from this so it doesn't happen again. So you've worked out an agreement where they're offering you 1 year in jail and this to be probated for 15 months. As part of this, you will do a repeat offender DWI education class, a victim impact panel, a TRAS, which is an evaluation to see what are the conditions you may need if you need other conditions. If they assess them, you must fulfill them. No drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. Guardian interlock, 25 hours of community service, and a $100 one-time donation to Mothers Against Drug Driving. You have children.
No, but I have a 13-year-old brother that relies on me.
If he does a parenting class, then I'll consider the community service way.
Thank you, Judge.
The idea, all we want is that you learn so that you, in 20 years, this has made enough of an impact on you that you think twice. Oh man, shit, that was such a bad experience. I don't want to do that again. It's either jail or it's a crap load of fines and fees. Do you understand?
Yes, sir.
If you ever have a problem while you're on this probation, all you have to do is come back, let us know. We can work through anything. There's nothing too big, nothing too small. But the worst possible thing you can do is drive without a license or insurance, start using, or pick up another DWI. So you understand?
Yes, sir.
The other thing that if you just take off, abscond, that's also an instantaneous warrant. If you violate this probation, that's what we do. We issue a warrant. We have a hearing to determine whether you violated it. If you do, you're looking at an entire year. Do you understand?
Yes, sir.
You give up the right, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, this is going on your record now. It'll be there for the rest of your life. Do you understand?
Yes, sir.
From now on, you're facing a minimum of 90 days in jail. You ever pick up another one. Do you understand?
Yes, sir.
And I'm going to tell you now, you get pulled over, an officer, the first thing they do is they look at your record. They're going to see DWI, DWI. What do you think they're going to do? Do you think they're gonna harass and harangue the hell out of you? Every time you get pulled over, and if they smell anything funky, it's probably not gonna go well. You understand?
Yes, sir.
Is it true or untrue that you had a 0.15 or above in this case?
True.
True to the enhancement. All right, how do you plead to the office? Guilty or not guilty?
Guilty.
I'm gonna find you guilty. I'm gonna follow this agreement. I'm gonna send you to it. I'm not gonna suspend your license now, but I'm gonna tell you, can you look up his license, please, to see if it's suspended?
Judge, I'm sorry, I missed his name.
Arredondo.
It is not eligible, Your Honor.
Okay, so you will be signing a non-driving affidavit. If you drove here today, you are not allowed to drive home. Your license is suspended as of this time. If we catch you driving without a license, I'm gonna lose it. Do you understand?
Yes, sir.
Do not drive. You are required to have a guardian interlock, and every officer, because we send notice to DPS, every officer in the state knows if they pull you over and you don't have an interlock, you're going to jail. Do you understand?
Yes, sir.
That's for the traffic, right? That's why it's ineligible, right? So
I
traffic.
don't believe so. I took care of those yesterday. So.
Judge, I believe his license may be showing ineligible due to a traffic ticket. If we can get that sorted, can we come back and?
I'm okay with an occupational as long as he's in compliance, okay? The other thing is this, is he is now taking a subsequent DWI education class. DPS is probably going to suspend your license regardless because of a subsequent DWI education class, if you've already taken it. Did he do a diversion and it got dismissed? As part of the diversion, you have to do a DWI education class. Subsequent ones get your license suspended. So I would check with DPS first. Don't just start driving, when you take care of that ticket, because they're going to probably suspend your license again. And this time it may be like a 2-year suspension. I'm okay with an occupational as long as he's in compliance.
Yes, Your Honor.
And he has an interlock first. Okay. All right. So we're going to have you meet with Shatoria for all your conditions, and then good luck to you, sir.
All right, thanks, sir.
Thank you. Waive the supervisor fee. Good morning, ma'am.
Good morning.
You were charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're entering into a very important agreement today where this DWI will go on your record. It's going to be there for the rest of your life. This is serious business because if you ever get pulled over again and you have some kind of funky smell, whether it's alcohol, whether it's dope, anything, it's probably not going to go well for you because they're going to look that you have a prior DWI. And do you understand?
Yes.
So I would never, even if you've had a sip of alcohol, get into a car because you're begging for trouble. We all make mistakes, but when you continue to make mistakes that you endanger other people's lives, the sentences get longer. The costs go skyrocketing. You understand?
Yes, I do.
So there is a $6,000 surcharge that would tack on because this is a 0.15. I'm going to waive it for you today. If you come back with another DWI, get ready because it gets a whole lot worse. Not only that, from now on, it's a minimum of 90 days in jail. You pick up another one. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine the accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
I understand.
Okay, how do you plead to the offense, man? Guilty or not guilty? I'm going to find you guilty. Send it you to 3. Is it true or untrue that you had a 0.15 or above?
It's probably true.
Okay. Do the enhancement. Okay, I'll send it you to 3 days in jail, credit for the 1 day that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license. I'm going to waive your supervisory fee, but be careful. You come back on another one, it's going to cost you an arm and a leg. Do you understand? For $50, an Uber, take you wherever you want to go. $50.
That's what I'm doing now.
Good. Good luck to you.
Yeah, and I do have a question. There is something weird with her license. We're unable to get a status of her license.
Yes, absolutely.
I think state did just a few minutes ago too, and they couldn't do anything.
Gaskin, his last name. I don't know. You know, that's something you may just have to call DPS to figure out. You have your license number, correct?
Yes.
This is the number, Deputy Brand, that's the number to the driver's license division of DPS. Call them right when the phone lines open at 7 and you'll get through. Don't try at 7:20, 1 o'clock, you'll never get through because they're so busy. But if you call right at 7 o'clock in the morning, you'll be able to speak to someone and they can tell you what the problem is.
Judge, even our orange, it won't populate, it won't return to anything. I'm not sure.
There's something's wrong. I don't know. I mean, we only get access to be able to put a number in and it'll spit out information as to the status of the license, why it is. I don't know. Maybe it's got to be an incorrect number or something. Maybe
It doesn't populate with a number, which is odd. It's just a symbol, and then it says an error.
Because in the one in that letter, it was saying something about
The website could be down too.
do something.
Oh, yeah, maybe the website's down. I don't know.
Or something.
I would call them. The best thing to do is straight from them, that's what I would do.
All right, and I do have one more question on this. I'm sorry. If we find that her license was previously suspended for 90 days, would you be willing to give her credit for that 90-day suspension?
Yes, but you have to give them the dates and everything.
Gotcha. Yes, sir. Thank you, Your Honor.
This right here is huge. Despite the chase, despite the suspicion, the judge says no probable cause. That's the Constitution in action. Reasonable suspicion gets you stopped, but it does not automatically get you charged. This is a reminder, police instincts aren't enough in court. Evidence matters. Drop a comment, did justice win here, or should this have gone further?
Approaching on Francisco Ochoa.
Okay, let's hear him, Bob.
He's on bond.
Page 24.
So, Judge, the court wanted Mr. Ochoa on docket today, because there was a new case that he was charged with. An assault that happened in the jail. He's currently on bond for tampering. There was allegedly an assault that happened at the jail. Yesterday I came into the court. Richard and I watched the jail video.
Okay.
There's absolutely zero participation from Mr. Ochoa in the fight in the jail. It's all on video. Zero participation. He's clearly in the video sitting down. That's the state. You have to ask the state that one. I have no idea. So Richard's been communicating with the felony prosecutor. He hasn't got a response yet. Currently, there's a warrant out for Mr. Ochoa's arrest.
Well, not a warrant. He's being held at no bond on the assault now, right? He's back there, right?
No.
Where is he now?
There's a warrant out for his arrest. He's in the building right now.
Right. I'm not going to do anything until I know where he is and we have him, right? If he's out on the lam or just out and about, I'm not doing anything until he's here, If you want me to address it and we do PC, I'm happy to do it, but not till he's here. I'm not going to, he's going to be here.
Because if he comes in.
I have he's in jail. I'm showing he's in jail for some reason.
So.
Are you not? It shows jail.
I don't, it's James, he's not.
Okay, so I'm happy to go through everything with you, but I'm not gonna do it till he's here, really. And if it is what it is, I mean, he's about as reasonable as he.
I understand.
And if show him, maybe he'll dismiss it
We
now.
just
I
watched
don't
it
know.
again today. We watched it twice. And
He doesn't want to dismiss it?
he wants to communicate with Richard.
Oh, he wants to talk to felony for something?
Right. But this is a misdemeanor case where.
Regardless, Mr. Haggard, I never do PC without the defendant being in here to do it, and that just goes with everything. With every single case, I never do PC unless they're here.
Understood.
If you want me to do PC, I'm happy to do it, but they got to be here. And then we'll do it. And then I'm happy to watch any videos that you have as well. We'll watch it all together and we'll make a decision.
Yes, sir.
I'm trying to be as reasonable as I can,
All right. Thank you.
All right. So, good afternoon, Mr. Hodges. So your charge is failure to stop and give information. You have worked out an agreement where they're offering you a 6-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It does not get dismissed. You merely take a probation, complete it successfully. You don't end up with a conviction. Do you understand?
Sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine the accusers, the right to be arraigned, charge rates in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, there's no turning back. Do you understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
Was there no restitution that was due in this? Hey, Blaze,
Yes, sir.
on Mr. Hodges, was there any restitution that was due? It's an FSGI. The agreement that I see so far is a 6-month deferred, no drugs, no alcohol, random testing, and 20 hours of community service.
There's no monetary damage, Your Honor.
No? Okay. Do you understand this?
Yes, sir.
If you get this done quick and there's no problems and you're nice to everybody, especially the probation officers, I'll take you off and half the time as a reward.
Yes, sir.
But if you pick up a new case, you take off, if you do something to violate this agreement, I will issue a warrant for your arrest and you're looking at 180 days in jail.
Sir.
You understand?
Yes, sir.
All right. How do you plead to the offense? Guilty or not guilty? No. It's either guilty or it's not guilty.
Guilty.
All right. I'm not going to find you guilty now. I will withhold that for 6 months, give you the opportunity to complete this. And if you complete it, that's when you don't end up with conviction. If you violate this, though, we put you in jail, bring you out, we'll have a hearing. And if you violate it, like I said, you're looking at 180 days. Do you understand?
Yes, sir.
Okay, good luck to you. Thanks.
Would you like Mr. Ochoa to come up?
Huh?
Would you like Mr. Ochoa to come up?
Not yet. He's here though, right?
Yes, sir.
So no, I mean, I've watched the video, Your Honor. From what I can see in the video, it appears he's sitting back, I'm being honest with the court.
Just the whole time, there's not participating in the assault. Does he provide some kind of assistance, encouragement? Does he say, hey, go get him? Or
So the video,
is it a party type?
honestly, the video doesn't have any audio, so I don't know if he's encouraging them, but it does appear that he's just sitting back on a bench.
So how would they find probable cause?
Unless they did not do their due diligence and put the finger on the wrong guy. Simply, period. It's clear as.
Cops will say, hey, look, this guy's a party to it. He was there. And they don't get access to the video to see it. And maybe they just, when they're doing magistration, they don't go through the video to look.
I
right?
mean,
That
at the
comes
end of the
later
day,
on.
Judge, with all due respect, before you charge somebody with the criminal offense and putting their freedom at stake, they need to make sure that is who they say it
I
is.
agree with you.
There's a number of people that beat the brakes off of somebody in jail, and Mr. Ochoa had absolutely nothing to do with it, period. He's sitting on a bench from a distance.
But I'm not, you'll find no argument.
And now there's
No idea.
and now there's an open warrant for him, which definitely would affect this court's case as well as the felony.
Look, because sometimes they'll give me information on how someone found probable cause, right?
So I mean, in the offense, there's an offense report saying that he was stomping and punching repeatedly the complaining witness. And it's clear as day, he didn't.
They got the names wrong. If there was a Francisco Ochoa, there's a Francisco, so there's different Franciscos. Maybe they got it mixed up.
So the cause number is 255-9198. And I have the video queued up if the court would like to see the video.
He's corroborated. I trust Blaze, I trust you guys,
And I'm being transparent on it.
Yeah, that's. Oh, so this is a 2B.
Yeah.
Active warrant.
Yeah, it's a 2B. So he's never even gone before magistrate.
Well, so
I just won't sign the 2B. I mean, God dog it, then we're gonna have that other problem because it's always gonna show like a warrant.
So you, what if you can find the PC? Is that what you're doing?
Yeah, I'm gonna find, I guess I'll sign it and say no PC on.
Can generate the PC form separately.
Okay, I'll do that. Blaze, I'm gonna find no PC if that's what it is.
Your Honor, I'm sorry, Your Honor.
It's okay.
Okay, I'll reach out to Felony before it's dismissed. I mean, I've looked at it, being candid here, me and Brad have talked about it. And I've reached out to Felony and I'll have an in-person conversation.
Do it sooner rather than later, because it's gonna show always warrant status until it, gets dismissed, right? I'll find no probable cause.
That time's not, it would just be defendant discharge.
Is that right?
Yes, Judge.
Okay, so that way, because I don't want them to get like pulled over and someone says, okay, so it'll show defendant discharged.
It's not dismissed at this
So,
time.
yeah, they have to dismiss it for it to really go away.
The warrant summons to generate, we have to take it to grand jury and get it done. I'm not saying we're doing that, I'm just saying that's how the warrant will generate.
So I'll find no PC.
Okay, all right, thank you, Judge. Thanks, Rich.
Thanks.
Yeah.
So Judge, I have two people to talk to you about.
Okay.
Is, Mr. O'Neill, yeah. So I was able to talk to his father finally, but he was at the hospital, checking on his wife, and he wanted to talk to me later. So I don't have an answer yet about, the home and everything, whether or not.
Roll to later this week and I can wait his appearance.
Sure.
And does he have a cell phone or no?
No, he doesn't have his cell phone's at the house and his ID and everything's at the house because they arrested him basically in his underwear. And so, but
She said that she's willing to put it outside the house, right? You want to schedule a time that he can come get it? Perhaps? You guys just coordinate a time?
Sure, do that.
Just tell him not to knock on the door, try to have contact with her, just literally pick the stuff up and go.
Now
They've got in garbage bags ready for him, so just coordinate a time.
and so right now he didn't have anywhere to stay. He's staying at Star Hope and every day he has to take everything with him, when you leave there.
I know.
But he can go through, I guess, and pick out what he needs and then, go from there. I did talk with his sister and family's trying to help him.
Stay with his sister. Here?
Sorry?
His sister here?
She's lives in North Harris County.
But he stay with her?
No,
She won't let him stay?
yeah, she doesn't want to have him stay with her. Muskee Road, way out there, 290. It's kind of far.
You don't want him to stay?
No. But she's not over the house and all that, so, but the dad was, but he just couldn't talk to me. He was, I didn't have a number for him, so I kind of knew where the hospital was, but his description, so I tracked on the hospital and.
Alienated, and you have nowhere else to go, but,
Yeah.
I mean, my fear is that if he goes back to the house, more bad stuff's gonna happen, and that's what we're trying to prevent, you know? I mean. Harold, I'll do whatever you want to do if you want to
Sure,
set it a week, a day, or later this week, whatever.
can we say like next Monday? That'll be good.
Whatever.
And then between now and then, I guess if,
Right, I mean, what I would say is if you could reach out to her, ask her what's a good day and time for him to come pick the stuff up, so she knows that she's not there, right? Maybe at the time when someone else is there, so that someone sees him getting it. So don't leave it just out by the front so someone else can take it, maybe leave it in the backyard or, just be conscientious because we don't want someone else to take it, and then, or maybe she can be there and that way she leaves it out right before he comes. That way someone doesn't take it. I don't know, Harold, what do you think?
yeah, we'll say Tuesday. I don't know, maybe if she could do, I guess we kind of need to know what day. Could you reach out to her now? You think she's available or
Yeah, I can reach out to her.
see what Wednesday or Thursday is a good day?
Yeah, and do you know a time that would work?
You guys decide that off so that I don't want to get involved and I don't want to live stream everything that, you know.
And then Judge, we also had Mr. Savage in the holdover. And he has an MAJ, in here on probation case. But while he was in drug treatment for the probation, he picked up another case. And then I think after he got out, the story I'm getting is after he got out of the probation.
Yes, so he
We
got
come back.
placed on probation back in 2022 for an assault. He completed a part of that probation, he was to go to SAT. And while he was there, he picked up a felony charge, they ended up putting him on probation. And then while he started going to aftercare, he tested positive for amphetamines, meth, and benzos, and then he just absconded from both our probation and the Felony's probation.
Okay.
And so that's why it's been a couple of years, right?
Yeah, I guess it's time to let's be done with it, right?
Well, he was asking me, I don't want to speak for him. I can't remember if he told me he's clean now, but he was interested in trying to restart everything.
I mean, really,
Too far out.
you get on the assault with us. While you're on probation for assault, you pick up a felony. While you're on both probations, you start testing and then get abscond. I mean,
I think the felony was getting drugs while you're in the program. So, I mean, I think it's really a drug problem. It's not a.
yeah, unfortunately, we don't have as many tools as felony courts has to address, and I don't know what they'll do up there. Perhaps they'll put them back on there and keep him in treatment. I don't know, but
Is it possible to, wow,
this thing's been going on for 2 years, you know?
how much did we complete of it? I didn't ask for that part.
My feeling is probably nothing because he's been in treatment for,
But just
they're in treatment or absconded.
And he's behind his feet in the aftercare. That's stuff.
So this is the kind of thing where we could terminate unsuccessfully, let him deal with the felony.
I mean, I'm willing to give him back time, but true to the, you know, I don't want to unsat term him because that would, in effect, he wouldn't end up with the affirmative finding thing, you know, and so I'm willing to do the back time, but you'd have to, you know.
We're just not sure if that will affect his felony one. Yes, it wouldn't, because it predates the felony. So it wouldn't, yeah. Okay.
And if you want a couple days to do research and think about it, I'm okay with it too. You want to do that?
You do that?
Yeah.
Sure. If we can.
So set it for maybe next week, take a look. But I mean, Harold, really, are we going to put him back on when he hasn't done anything? Get absconded, had dope while he's in treatment, and then he's still doing while he's out.
Just sound like we didn't commit to it initially. You know, we weren't really struggling with it, with the addiction, maybe, and not committed.
I get it. But at some point we have to say when. And I think that's not. But I'm willing to give you time to look to see, and, you know, maybe get in contact with a felony lawyer to see, you know, whether it would have any kind of impact or not.
All right, pause right here. This is where the courtroom temperature spikes. What you're hearing isn't just a rap sheet, it's a pattern. Judges look at repeat offenses like this and think one thing: risk. And when a defendant misses court on top of that, that's a fast way to lose the court's trust. Let me ask you, should past mistakes define someone forever? Or does accountability finally have to kick in at some point?
So, Mr. Chanel Robinson, we were here earlier this week, and I was just appointed. There was a lot of jurisdictions involved in this case. So he is on a fugitive bond out of Virginia, Chesterfield, Virginia.
Oh, I remember now. That's right. Yep.
Here's the homework that I've done. So I contacted the sheriff that put out the warrant for his arrest. And so
From North Carolina?
No, Virginia. So
Right. The original warrant's from Virginia.
yes, original warrant that caused all this stuff is from Virginia. So I talked to the sheriff. Sheriff says, hey, we don't have any info. Or I can't give you info. Talk to the district clerk. I talked to the district clerk. Hey, when's his case setting? does he have a bond amount? Is it at zero? What's his case number? There is no case. It's not in the system. We don't have anything in the system. The best we can tell you is call the detective. Okay, so I called the detective.
It's like a fishing expedition.
Yeah, so I called the detective, hey, what's going on here? What's the case number? Is there a chance he could post bond out there? How does it work? Well, my understanding is it's kind of like a 2B warrant where he's not in the system yet, but they want him. So at that point, he needs to touch Virginia. So he was in this situation where he had this fugitive warrant in North Carolina, okay? Now, in North Carolina, they hit him with the case, and they also hit him with the fugitive warrant out of Virginia. Now, that case, not the fugitive case, but the original case was dismissed because he was arrested before committing a crime. So they dismissed that.
Wait. What was dismissed?
So
The North Carolina one?
North
or-
Carolina. He had two cases out of North Carolina. One is a charge for felony conspiracy. That
Really?
was dismissed because he was arrested before committing a crime here. I don't know how they put a case on him if he didn't commit a crime there.
Well, that's why it was dismissed. I mean, it
Yeah.
looked like they wanted to hit him with a conspiracy, but they arrested him prematurely.
I guess so. And so that one was wiped out. So then the only thing left is the fugitive case from Virginia. Okay, so he's got to answer. So he posted a bond out there. And so he's got until he hasn't absconded over there technically because his hearing is not until
August 14th.
August 14th is when he's supposed to show proof. So he hasn't gone to Virginia yet, but he had until August 14th to do so. And so my argument is he hasn't violated anything in Virginia yet. He is not absconding from Virginia. There is no case in Virginia yet. How they had this fugitive warrant, I have no idea, but I would argue that.
The warrant doesn't go away, Ricardo. Just because you post a bond in North Carolina, that gets you out. But the original warrant from Virginia always remains active, and it will always remain active until you go to Virginia. So if, hypothetically speaking, I were to give you $1 bond now and let you out, you would still have the Virginia warrant. And that warrant will be a balloon or an umbrella over your head, a dark cloud, until you go turn yourself in. The problem is that you got picked up here before going to Virginia. Your first thinking when you got out in North Carolina should have been, you know what? I better go to Virginia before I get busted somehow, some way, somewhere else. But instead, you made the decision to come to Houston. That's what you did. And unfortunately, you got busted. Therein lies the rub. So why am I supposed to feel sympathy for that?
Well, because the only argument is he had until the 14th. He did mess up, didn't go directly there. Yes.
And he did theoretically do something because they filed a conspiracy case on him in North Carolina. It's just that whoever the officer was premature. So he muffed up the case.
I'm assuming what happened in North Carolina, what's the original charge in Virginia? Is it conspiracy as well?
Robbery threat and robbery threat conspiracy.
Conspiracy, there you go again.
Another robbery case.
Another one, but who's to say he hasn't even presented himself? They want him to go turn himself in. Once he presents himself, he will, what's to say they're not going to dismiss it like they did over there? I mean, he's got the opportunity to go and handle it.
How much was the bond that he posted in North Carolina?
I'm just supervising, Judge. I'm gonna let Amy.
I know, Amy. Hashem, how much was the bond that he posted in North Carolina? I would be interested. And does North Carolina know that we picked them up?
They do now.
Have they revoked that bond? Or are they going to?
No, I mean, that part, Ricardo, is correct. If he had until 8/14, but the issue is, and this is neither here nor there, is whatever probable cause the officer had for a traffic infraction or whatever it was that got the probable cause to run the warrant, that could be used to revoke. Now, I'm not saying they will, but I'm saying it wasn't a vacuum. It's not like he walked in the middle of a street, committed no infractions, and an officer just randomly looked at his face and said, I know all the information by heart. So he committed some other infraction for the officer at probable cause to run to get the warrant in the first place.
So Judge, as far as North Carolina is concerned, I got in contact with the PD that handled or who's responsible for his case out there, Mr. Seth Bullard. Now, he let me know what happened out there. He's got until the 14th to turn himself in. I let him know that he's currently in custody here, and if he doesn't get out, he's likely not going to be over there. So he understands that nothing has touched North Carolina based on his arrest here yet, because he had until the 14th to resolve that.
It is worth noting that it's about roughly 3 some odd hours from Virginia to North Carolina. It's about 21 hours to get from Virginia to Texas.
And again, this 20-year-old should have just gone directly to Virginia, but on playing the devil's advocate and advocating for my client, you know, he had until the 14th. Okay.
If history is any indication, we give him a bond. Where's he gonna go now?
Well, hopefully he goes directly to
Mexico?
Virginia. No, hopefully he goes directly to Virginia, and we're not here in this position anymore. He goes to Virginia, touches there, and handles his business, because this is the second time he's been picked up on this Virginia issue.
You know what they say about assumptions, right? What should I do, Mr. Robinson?
He hasn't messed up in your court yet, Judge. And technically, he hasn't messed up in North Carolina yet either.
A bond was paid, so money's already down.
Yeah.
Second here in Virginia.
Yeah, that's an opportunity for him to make it right. I'm fighting for the
I
opportunity.
wanna talk
for
to
him
Mom.
do that. Let me see when I talk to this number. Yeah, that's the number.
And what's her name?
Davida Robinson.
Davida.
Hello,
Is this Miss Davida?
this is she.
Hi, my name is David Fleischer. I'm a judge here in Harris County. And you have a Traynald Robinson Ramirez.
That's correct.
Who is that?
That is my son.
You know, I've got him in front of me now. I've got his defense lawyer with me right now. I've also got the state of Texas, the prosecutors with me. And what we're doing is we're debating whether to give him a bond because he's wanted out of Virginia for, what is it, guys?
Robbery threat and robbery threat.
So for a couple robbery cases.
Yes, sir.
And were you the one that posted the bond in the North Carolina case?
Yes, yes, I was.
How much,
Virginia,
yeah, how much was the bond in North Carolina?
20,000.
Do you realize what happens if he takes off?
That's why I've been trying to get him out of there because he has to be in court on the 2nd.
On the 2nd?
Yes, sir.
We've been hearing here that he's got to be in the court on the 14th. Hey, ma'am,
No Virginia paper.
can you, let's do this. Can you send Ricardo, the defense lawyer, a copy of the paperwork that you have saying the August 2nd date? Whatever you have saying August 2nd, can you send a copy of that to Ricardo? I'll give you his phone number. Take a picture of it and send and text it to him so we can take a look at it.
Yes, sir.
Judge, we could go straight to the horse's mouth with the detective from Virginia. I have his number.
But he wouldn't control what the courts do.
I got the number to the courts where they're gonna tell you it's not in the system also.
Just give it a second, Ricardo. I mean, we've taken this much time anyways. Let's just see what she has.
Okay,
Really. I
sounds
mean,
good, Judge.
What's the harm? I mean, we're here anyways. It's 1 o'clock.
Hello?
Ms. Davida?
Yes, sir.
Hey, this is Judge Fleischer.
Yes, sir. Did you get the paperwork?
We did.
Okay.
And the deal is this, is that it looks as if that they had charged him with a conspiracy case in North Carolina.
Okay, yes, sir.
That case was dismissed from what they're telling me. Let me see.
This is what Mr. Vita sent. It has both their cases. 704 is North Carolina. The room number is for the North Carolina setting. So 82 and 814 are what were both in plain North Carolina until 82 got dismissed. So the only thing in play is 814.
The case from 8-2, according to the defense lawyer here, Ricardo, that case was dismissed. So you no longer have to worry about it.
Thank you.
The only case that's in play now is the Virginia case where Mr. Robinson has to make it up to Virginia by 8:14.
Okay, that won't be a problem.
Hold on a second.
He needs to show proof in North Carolina that he's handled Virginia by 8:14, but there really is no setting in Virginia yet. So ideally, he's gonna go touch base with this sheriff or detective and let him know, hey.
Well, he has to go turn himself in. That's bottom line, right?
Yeah, in Virginia,
So
yes.
what has to happen is he has to go turn himself in to Virginia by 8:14.
Show proof in North Carolina.
He has to show proof to us here in Harris County and to North Carolina. If he does that and proof is shown, both of those cases, the fugitive cases out of North Carolina and here in Houston, will be dismissed.
Okay.
Do you understand?
Yes, sir.
I am going to set bond at the same amount as the other one. It's the only way that he's going to get it.
Here's the thing though, Judge, my understanding is they didn't have to post 100% bond in North Carolina for some reason. I think it works differently out there. If you could inquire as to how much was actually posted, I don't think the full.
How much did you post of the $20,000 bond in North Carolina?
5,000.
That's too low for me. I'm not doing 5,000.
Okay.
I'm telling you that now, because I number one, I don't trust Mr. Robinson, and I need to know that there's enough blood in the game that he's going to actually make it.
We got another one that I just bonded him out on the 75,000 one. I signed paperwork of that one as well.
What case is that one?
That's for the Virginia. His attorney has the $75,000 bond and the 20,000 I sent him yesterday.
If he posted that $75,000 bond, then this case should go bye-bye.
So Judge, that's not for Virginia. She
He
posted.
has the lawyer has both of those bonds, 5,000 and 50,000.
Let me see.
So both of those cases are here.
Because I have to tell him that I posted both bonds.
Both of you are speaking. I can't hear it. Hold on a second. Hold on. Okay. Tell me what you were going to say, ma'am, please.
I sent both paperwork for both bonds, the 75,000 and the 20,000 to his attorney yesterday by bill text.
Post it to get out of North Carolina.
Judge, my client is telling, and I don't have access to Virginia, but he's saying that they did post a bond in Virginia?
That's how I got out of North Carolina.
If you posted bond out of that jurisdiction, then our case should go away. But we need proof of that.
I brought the paperwork to the precinct. They told me I had to talk to the attorney.
If you
She sent me the paperwork. That paperwork.
look at this, hey, come here, look at this, Jay.
I don't know.
Look at this last page.
Call it bonds, judge, people Greens Point bills.
So he is out on 2 bonds as of now.
So
Greens Point.
No, that last page, Day, says that he posted a 75,000, but, and I don't know where that paperwork is from.
Judge, this is interesting what my client's telling me. Tell me what you just told me.
They dropped the warrant when I posted my bond in North Carolina. Virginia dropped the warrant, and I had to post that bond to get out of North Carolina because they was holding me.
That's what we need, but Day needs to be able to verify that. If he can verify that you posted bond in Virginia, then this thing goes away.
I posted bond from Greens Point Bills bond. I think they should have the paperwork.
I don't understand. This is still talking about the North Carolina, though. Were you trying, was this?
Does that not say that bond was posted in Virginia? Why would you come to Houston in the first place?
Because they told me he didn't have to appear into Virginia
That's what I
until
was thinking too.
August.
Why go immediately when they give you a couple weeks, right? Why would you go turn yourself in? I wouldn't. You know what I mean?
Yes.
They told me we had all the way until the 14th to be back in Virginia.
Day, who wants to go early? Right?
And this is Merkenberg.
Do you want to see if
I ended up having to post another bond because they wouldn't release him on the first one. That's how we even signed it. I didn't even know anything about Virginia until I posted the first bond. I had to remake an additional bond for the $75,000 bond for out of Virginia so he can be released.
I don't want to just set a bond now. You put up $20,000 for nothing.
Ma'am, just so we don't go in circles, what I will do is I will call Virginia after docket today. And I will make sure to get something in writing from both the court and the sheriff's office there that they have not released the whole. But, and I say the second part because I cannot give out legal advice, is if and when your son returns to Virginia, is you need to go out of your way to contact North Carolina. Because bonding companies, they make a living and they're not gonna go out of their way to return your money. So you need to contact all the places that you posted a bond for, and you need to be able to file the paperwork, okay?
Dang, Day, you're so nice.
Just.
Okay, well, I'll just wait and see what tomorrow.
So we're gonna roll this to tomorrow then?
Okay, yes, sir.
Yeah, okay. All right, let's regroup tomorrow. We'll see. You know, the idea is that your mom's posting all this money for you, man. So number one, I hope you appreciate it. Number two, we're gonna roll it to make sure that she doesn't have to pony up a ton of more money, you know, because it's a lot of money. And, you know, I don't know if she's rich or not, but a lot of people just don't want to give up 20 grand just for, you know.
An astronomical small chance that Virginia actually did release the hold in the last 48 some odd hours, and obviously this is all for moot, and I'll dismiss the case today, so I'll find out after that.
Okay.
Sounds good.
All right.
Thank you, everybody.
Thank you, Dave. Appreciate it, man.
Thanks for staying. Thanks for being patient, guys.
Appreciate it.